Bismillahirrahmanirrahim. Rabbi shrah li sadri wa yassir li amri wahlul 'uqdatam min lisani yafqahu qawli. Assalamualaikum warahmatullahi. In my previous video, I've already talked on the need for actus reus and mens rea. Without actus reus or mens rea, a person cannot be guilty of a criminal act. Now, under this topic, I'm going to discuss on omission. The question here is that, is an omission an offense? Can an omission be considered as an offense? The general rule is that criminal liability is attached to conduct comprising positive activity by the accused, but not his failure to act. Thus, a person who drowns his enemy by holding his hair and then holding him under the water will be criminally liable, but not if he does nothing upon seeing his enemy drowning. If he push someone's head into water, causing him to drown, then it is a criminal act. It may even be murder. But if he sees someone about to drown, but he does nothing, he does not save that person, does nothing to stop that, it is not generally, that is not a crime. However, of course, there are exceptions to this rule. So that is a general rule, but that there are exceptions. Words referring to acts include illegal omissions. Under Section 32 of the Penal Code, in every part of this code, except where a contrary intention appears from the context, words which refer to acts done extend also to illegal omissions. So what is illegal? Illegal is defined under Section 43. The word illegal is applicable to everything which is an offense, or which is prohibited by law, or which furnishes ground for a civil action. And in respect of the word illegal, a person is said to be bound to do whatever it is illegal in him to omit. So the first one, if you look, failing to act when it is an offense. The first situation where an omission is an offense. The general rule is that an omission is not an offense. However, there are exceptions to this. So, and one of it is that when the law says that it is an offense, when the law makes it an offense. This refers to omissions which are expressly made offenses by the Penal Code. For example, Section 289, Section 187, Section 119 of the Penal Code. Let's look at one of the examples, one of the provisions. Section 187 makes it an offense for persons who are bound by law to render assistance to public servants in their execution of the public duty, to intentionally omit to give such assistance. Meaning, under this provision, the law says that it is a person is bound by law to render assistance to the public servants under the situation stated under Section 187. If he omits to do that, it is an offense. It's clearly stated under Section 187. And then we can see the case of Lee Sayan against a public prosecutor, where the law makes it an offense to do that act, then it becomes an offense. When the law makes it an offense to omit to do such act, then omission to do such act, not doing something to protect the act, or then it becomes an offense. You can refer to my slides later on. And then another situation, failing to act when prohibited by law. This is a situation where the omission was prohibited by law. What is prohibited by law certainly includes omission which are expressly made offenses, that the previous situation just now. But the term is not restricted to these offenses, but it is wide enough to cover other situations. For example, examples of the situations under this failing to act when prohibited by law. Section 68 of the Singaporean Women's Charter provides that it shall be a duty of a parent to maintain or contribute to the maintenance of his or her children by providing them with such accommodation, clothing, food, or education as may be reasonable. So it puts the duty on the on the parent, on the parent. A failure by a parent to discharge this duty, as stated under Section 68 of that charter, is prohibited by law. But it is not in itself an offense, because the law doesn't make it an offense. There is no punishment under that provision. So in that situation, it is a situation where the act is prohibited by law, even though it is not an offense. Right? It is not an offense for the omission of such thing, but the omission of such thing is prohibited by the law. You can see the case of D'Souza, Pashupati, Nath Sanka, the application of the situation where the law prohibits such omission. Now let's look at the third situation, failing to act which furnishes ground for civil action. The third set of circumstances requires a court to determine whether a particular accused omission would attract civil liability. Failures to act which furnish ground for a civil action are most commonly related to tort law, in particular the tort of negligence. Similar to criminal law, tort law has a general rule imposing a legal duty of care in respect of positive activity which might harm others, and imposes such a duty of care for omissions in exceptional situations. Such duty may arise when, number one, where there is a special relationship. Number two, a duty is voluntarily assumed. Number three, a duty arising from the creation of a dangerous situation. And lastly, a duty is assumed by contract. So let's look at the first one, special relationship. The civil law imposes a legal duty to act where a special relationship exists between the defendant and the person injured by the defendant's omission. For example, the relationship between a parent and his young child, so that if the parent fails to feed the child and the child dies, the parent may be civilly liable. Since the parent's omission furnishes ground for civil action, the omission is illegal and can therefore form the basis of criminal liability. And then the second situation, duty voluntarily assumed. Even if there is no special relationship between the parties, a legal duty to act will be created if any person voluntarily assumes responsibility for a physically and mentally infirm adult who is incapable of looking after himself or herself, as can be seen in the case of R against Instant. The accused lived with a 73-year-old aunt. The aunt was healthy until before her death. She developed gangrene in her leg. During the last 12 days of her life, she could not fend for herself, move about, or summon help. Only the accused knew of her state but gave her no food, nor did she seek medical assistance. The accused was charged and convicted of manslaughter. Manslaughter by omission, by not giving her food, by not sending her to the hospital. She appealed against that conviction. The court affirmed her conviction, stating that there was a common law duty upon the accused to provide food for the deceased, which she failed to discharge. So in this case, she voluntarily assumed that task of providing food for her, for the aunt, because she stayed with her. So she put herself in such a position. So because of that, she voluntarily assumed that duty. Therefore, her omission is considered by the law to be illegal omission. And another situation, duty arising from the creation of a dangerous situation. The civil law also imposes a duty of care in respect of omissions when the defendant has negligently created the dangerous situation. And this can be seen in the case of R against Miller. In this case, the appellant, while squatting in someone else's house, lit a cigarette and fell asleep before she finished smoking the cigarette. It fell onto the mattress, so he created the fire. Later, he woke up and saw the mattress smoldering. Instead of clearing out the fire, stopping the fire, he did nothing. He proceeded to another room and went to sleep again. The house caught fire. He was rescued and charged with arson by his failure to stop the fire. The court ruled that once he discovered the smoldering mattress, he was under duty to act. So, because he created the dangerous situation, the court held that it was his duty to stop the fire. Failure to do so, it was considered by the court to be an illegal omission. So it may be a criminal omission. Another case, the case of Benoy Chandra Day against the state of Calcutta. An uninsulated live galvanized electric wire had been connected from the house of Gopal to that of the accused. A 13-year-old boy, while passing in front of the accused's house, touched the wire and died instantly from the electric shock. The court held that, as the accused knew about the electric connection and failed to switch it off, his omission to switch it off, his failure to switch it off, was considered by the court to be an illegal omission, and therefore he was guilty of criminal negligence causing death within the meaning of section 304 capital A. So these are the situations, all these, as I already explained, yes. All these are the situations where the omissions may be considered as a criminal offense. But the general rule still stands. What is the general rule? The general rule is that an omission generally is not an offense. However, under certain situations, under certain exceptional situations, the omissions may be considered as a criminal offense. Okay, that's all under this topic. Assalamualaikum warahmatullahi wabarakatuh.